any technical difficulties that we have. I have been practicing construction law for about 12 years and have been assisting, and for many years I have assisted contractors with not only the DOT's Disadvantaged Business Enterprise Program, but also the state, local, and municipal programs. And probably for about the first 8 years of my practice, we didn't see much in the way of enforcement activity in the area. People, it was more along the lines of people being registered as DBEs, and there was very rarely a challenge to a DBE status, let alone an enforcement action by an authority. That started to change probably about 4 or 5 years ago, when we started to see an uptick in enforcement activity by the federal authorities. And it's something that is not only become anecdotal, but one of the things we'll discuss today in the seminar is the empirical data given by the Department of Transportation's Investigator General about the dramatic increase in compliance and enforcement actions, and also Department of Justice related actions, criminal actions, and civil penalty actions brought against contractors and individuals that have violated the program. And it's now become such a hot topic that this firm practices nothing but construction law. Very rarely do I get an unsolicited call from folks related to a construction law issue. They're mostly referrals, except in the area of DBE compliance. We received, because of our writing on the topic and representing other parties, we receive regularly unsolicited calls from across the country from contractors concerned about complying with the DOT's DBE program, as well as state, local, and municipal DBE programs. And as one client recently told me, folks in the industry are really scared to death of what is happening in terms of enforcement. So just by way of background on the program, as we let the slides catch up here, the DOT's DBE program has been around since 1980, so it's roughly 35 years old, and it was Congress passed the DOT DBE regulation as part of a highway funding bill in 1980 in order to increase the participation of minority and women's business enterprises in federally funded transportation projects. Congress has reauthorized the DOT's DBE program every year since 1980. Most recently, it reauthorized it in, I believe, 2012 with the MAP 21 transportation funding program. And not only at the federal level, but state-funded programs, county-funded programs, municipal-funded programs have passed their own similar DBE, MBE, WBE ordinances looking to increase the level of participation by minority and women-owned businesses in the construction industry. As with any program that is viewed as a set-aside for a specific group, the programs are controversial, but for the most part, they're constitutional. I am not going to spend much time. We could actually spend the whole program on the constitutionality of DBE and MBE and WBE programs. But the focus of today's presentation is going to be to comply with those that are presumably constitutional in the way they are tailored. Excuse me as I let these slides catch up again. I'm having little bit of difficulty on my end, but let's see if I can speed it along. Here we go. So what are the reasons why you need to be scared to death of this, as my client shared with me, and as the industry is? It's rightfully so. Right now, compliance with the DOT's DBE program is critical because, number one, if you don't comply, executives in the company face jail time and civil penalties, as well as the corporation itself can face jail time and civil penalties. You also face the threat of whistleblower lawsuits in the form of False Claim Act actions, which we'll talk about. I talk about whistleblower lawsuits as sort of the hidden danger of not complying with DBE programs. And when I refer to DBE programs, I'm also referring to MBE, which is Minority Business Enterprise, and WBE, which is a Women Business Enterprise program. So when I refer to DBE, I don't want that to be an exclusive term. So just so we know what I'm referring to when I refer to DBE. The second, what I call hidden danger of failing to comply with a DBE program, is a rejected or challenged bid. And the fourth being a post-completion audit, which could result in folks seeing money have to be returned, final payment challenged, and a whole host of other issues that arise from that, which we'll talk about. So where do you find what the requirements of a DBE program are? Well, they appear at 49 CFR 26 of the federal regulations, if you ever want to review those. That set of regulations applies to Federal Highway Administration projects, transit projects, that would be regional transit authorities, such as, in my neck of the woods, southeastern Pennsylvania, SEPTA, or even a regional transit authority that encompasses multiple states, like the MTA up in North Jersey and the metropolitan New York area, and airport projects. It applies to any projects that receive funding in whole or in part through the Department of Transportation. So the project itself does not have to be owned by that federal authority in order for the requirements of the DOT's DBE program to apply. There is a similar set of regulations that apply to FAA airport concessions. That's not necessarily construction related, so we're not going to spend much time on that. But the regulations, for the most part, are substantially the same. Now, the regulations are quite robust and complex. And like I said, if you feel the need to review these, you certainly can. However, in my opinion, the regulations boil down to remembering three major components. That the goals that are set as part of a DBE program are what they are, goals and not quotas. That you need to use good faith efforts, and that any DBE that's hired on a project that has DBE regulations perform a commercially useful function. If I had to pick out one of those three items that if you left here today and remembered, it would be the term commercially useful function. And we're going to talk about what exactly that means in the context and why it's so important when we're looking to comply with DBE regulations. These slides are giving me problems here, excuse me. Just bear with me a minute here. So who needs to comply with DBE regulations? Well, first and foremost, prime contractors, those that are in that direct contractual relationship with the Department of Transportation itself, or a state transportation agency, your state level agency that is receiving those federal highway funds. A county agency that's receiving federal transportation or highway funds, and like I said, a regional transportation agency, someone like the MTA or SEPTA, what have you, that is receiving funds in whole or in part as part of the construction of a transportation project, whether it be a highway project, a mass transit project, or like I said, anything receiving that federal funding. This DBE rules don't necessarily apply. The DOT rules don't necessarily apply to any project receiving federal funding. It has to be funding that flows through the Department of Transportation or one of its subsidiaries, the Federal Transit Administration or the Federal Highway Administration. It also applies to subcontractors and their subcontractors for two reasons. By virtue of the subcontractor or subcontractor being a certified DBE, or by virtue of the subcontractor or subcontractor having a contractual requirement to follow DOT rules. At the state transportation agency level, and then also in the federal regulations, they do not specifically call out that they apply to subcontractors. It is by virtue of the subcontractor being a DBE or having certain contractual language in its contract that obligates the subcontractors to comply with DBE regulations. And we're going to go back. What are the major requirements? First, good faith efforts. Contractors that have agreed to a DBE goal must use good faith efforts to meet and maintain that goal. The goal is not a quota. It's not a specific set-aside. And when we talk about later in the program certain things you can do, and where the good faith efforts becomes very important for compliance is when you're faced with a bid challenge or rejection, when you come up maybe just short of that DBE goal and you still want your bid to be accepted by a state transportation agency. You must demonstrate good faith efforts. Those are efforts that are real, sincere, that show an aggressive posture by the prime contractor in soliciting work from certified DBEs. You also have a duty as a prime contractor to maintain the stated DBE goal. Now, what does that mean? That means that, for example, if you have $1 million contract and you get a change order for $250,000, if you have agreed to a 10% DBE goal, you are going to have to show good faith efforts in making sure that at least $25,000 of that $250,000 change order goes to certified DBEs. And the same rules apply in getting the work performed by a certified DBE for that change order work as it does for the base contract work as well. So remembering good faith efforts, the use of them in soliciting contractors to begin the work, and also maintaining the goal throughout the project. It's also your responsibility to monitor compliance. And again, here's where we're coming into a big issue where you can't do business as usual. We're going to talk about in a minute how lack of knowledge of a potential DBE fraud is not going to be a defense to two of the major risks that you faced when you're working on a project that's under a DBE regime, that being criminal penalties and also whistleblower actions in the form of False Claims Act. It is your duty to make sure that if somebody has certified themselves as a DBE, that they are performing a commercially useful function throughout the project. Slides are not cooperating with me here. I'm sorry. We've talked a lot, and at least initially, about the term commercially useful function, and that's something I said to you is something that if you leave this webinar today, that is the one thing that you need to take away. What is commercially useful function? The regulations give a fairly detailed definition of it in what regulators should look for in determining whether a DBE is actually performing a commercially useful function on a project. It boils down to, is the DBE actually performing work on the project? When you boil down all the legalese that appears in the regulations are designed to ferret out those contractors that are DBEs that are actually performing work, that are real contractors, that are performing as would any other contractor on that project, from those that are just a shell entity and a sham entity. That's really what you need to look for. The only bright line test that appears in the regulations is that if a DBE subcontracts 30%, it must perform 30% of the work for which it's subcontracted with its regular employees or those hired specifically for the project, meaning those maybe potentially brought out of a union hall. If they don't perform with at least 30% of those forces, there is a presumption that that DBE is not performing a commercially useful function. Now, some statistics here, just to drive the point home. I was talking about some of the anecdotal stuff that we see at the firm regarding the uptick in DBE frauds, the DBE fraud investigation, both by the DOT Investigator General and the Department of Justice. This spring, the Department of Transportation, at the request of Congress, audited the DBE program. And included in that audit, there were certain statistics that, if you are a contractor, should scare you. The first is that DBE fraud-related cases represent over 1/3 of the DOT Inspector General's open cases currently. From 2009 to 2010, the number of open DBE fraud investigations increased by almost 70%. And from October 1st, 2003 to September 30th, 2008, and I don't know why they picked that time period for a report that was that was issued about a year ago. But in any event, the statistics were 49 indictments, 43 convictions. Don't know what happened with the 6 other folks. They must have had some pretty good defense attorneys. $42 million recovered by these investigations, and probably the most striking figure, 419 months of jail sentences that were given down. Now, there's another thing that is important about where these figures come from. This audit was at the direction of Congress. And if you know anything about federal agencies and congressional inquiries, you'll know that when the congressional inquiry happens, it really shines a spotlight on that agency. And the agency is going to aggressively try to patch any holes that appeared in its own audit of the program. And in fact, the DOT's audit did reveal areas where the DOT needs to improve its enforcement action. And lo and behold, as we monitor these enforcement actions, you also see the DOT is out hiring new agents to specifically work on DBE fraud cases. I am on the DOT's Twitter account, and every week there's a job posting for investigative agents. I think they're hiring 5 in New York right now because they want to increase their field staff to ferret out these instances of DBE fraud, and specifically DBE fraud. So when we're talking in terms of DBE fraud, what are the 2 most common types of DBE fraud? The first is what's called a pass-through scheme. That is where a certified DBE does not actually perform any work. What happens is the DBE is just a figure. It's a placeholder. They are put on a prime contractor's bid sheet as the DBE that would be performing a portion of the work that the contractor agreed would be performed by certified DBEs. However, they don't actually perform any work with their own forces. They don't perform work as any other contractor typically performs work on the construction project. In exchange, what the DBE gets they get a commission, they get a kickback, and the work is actually performed by a non-DBE firm, and in some cases, the prime contractor's own forces itself. That, by and large, makes up a large portion of the DOT's enforcement actions, and when we look at some of the Department of Justice-related criminal actions, they're almost always pass-through schemes. It's also important to underscore that because as I started today, I mentioned that it's, as a prime contractor, it's your duty to make sure that monitor compliance and monitor the fact that DBEs are performing a commercially useful function, and you can't stick your head in the sand. One of the things we're going to refer to today is something called the ostrich defense. The ostrich defense does not work when it comes to a DBE enforcement action. The other less prevalent, however no less serious form of DBE fraud is a front scheme. There, the DBE is a certified DBE. They are actually owned and controlled by a socially and economically disadvantaged individual. However, they're not actually the true owner. They're a front. So you have a DBE, you have that person that meets the definition of socially and economically disadvantaged individual. But the person financing it, the person supplying all the capital, the person taking all the risk is either another non-DBE company or a non-socially and economically disadvantaged individual. Moving on, there are probably two big, and I've somewhat have touched on these already, two big DBE compliance misconceptions. The first is, I am okay if I used certified DBEs. You're not. 100% of DBE enforcement actions involve the use of a certified DBE. So just picking that person off the list or that firm off the list that happens to have the certification from the state certification agency is not going to be enough. Because like I said, 100% of DBE enforcement actions, False Claims Act actions, bid challenges involve certified DBEs. And the other is, as I mentioned, the ostrich defense. What I don't know can't hurt me. So we mentioned pass-through schemes. I could probably have picked from 100 different examples, but I'm trying to pick ones that are maybe well known to the general public and some maybe that cut close to home for me. So an example of a pass-through scheme, a prime example, and one of the most high-profile ones in recent memory, is U.S. versus Marichalan. It's known as the Perini case because it involved Perini's Corp, now Tutor Perini's civil division, and it involved Marichalan, who was the president of Perini's civil division at the time. What happened? Marichalan and others within the Perini organization engaged in a DBE pass-through scheme. Perini was obtaining contracts from various transportation agencies in New Jersey and New York. They were certifying on their bid forms, on their payment applications, and on their closeout documents that a certain level of DBE participation was utilized, and they were certifying as to what particular DBEs, who they were by name. In reality, the DBEs that Perini certified as performing the work performed little to no work. They performed no commercially useful function. Who performed it? Other non-DBEs, in some cases, Perini's own workforces, and in exchange, as is typical in a pass-through scheme, the DBE firms received a 3 to 5% commission. In total, Perini obtained something like $17 million worth of work by falsifying the DBEs that were performing the work and not performing a commercially useful function. So what happened? Well, Marichalan was found guilty after a 4-week trial, and tragically, he committed suicide before he was sentenced. The co-defendant, who was Perini's head of purchasing, paid a $100,000 fine. I note that he probably paid legal fees 3 times that amount in defending the action, and he was placed on a year of probation. Perini itself paid $9.7 million plus legal fees in resolving the issue with the Department of Transportation to settle it, all over the lack of using using DBEs who were not performing a commercially useful function. Another example of a pass-through scheme, one from my neck of the woods in southeastern Pennsylvania, U.S. versus Tullio. They're a very well-known prime contractor in the area, JMG Construction, hired a non-DBE, Tullio Landscaping, for work on a project owned by SEPTA, which is the Southeastern Pennsylvania Transit Association. Again, I want to point out SEPTA. Here you have a project that is partially funded by Federal Transit Administration funds. So this is not a project that was owned by the DOT or a state transportation agency in the form of a highway agency. This is a regional transportation authority, but yet the DBE rules still apply. JMG listed a company, Pullens Trucking, as a certified DBE to Tullio, and the DBE rules do allow subcontractors to be counted towards the goal. So it was okay that Tullio was subcontracting with a certified DBE, and that JMG was using Pullens towards its goal. However, Pullens was not performing any commercially useful function. In fact, Tullio was performing all of the work for Pullens. And to make matters worse, Tullio engaged in a complicated scheme to make it look like Pullens was performing the work. He falsified checks to Pullens. He falsified applications for payment that had made it appear that there was indeed an arm's length dealing and that Pullens was performing a commercially useful function. In reality, like I said, JMG and Tullio were performing Pullens' scope of work, and they were just paying him, as is typical in a pass-through scheme, a 2.5% fee. An investigation resulted. Charges were brought by the Department of Justice, the U.S. Attorney's Office. What happened? JMG was forced to pay $1.27 million in restitution. And what I think is probably worse, so they've received a 5-year debarment from the U.S. Department of Transportation. So they were no longer permitted to work on what was probably very lucrative projects for them. Michael Tullio, for his part in the role, he was the subcontractor that was falsifying these reports. He received 15 months in federal prison and was ordered to pay $40,000 in fines. Switching gears, the front scheme, and I touched on it a little bit. What exactly a front scheme entails? In order to get certified as a DBE, the socially and economically disadvantaged individual's ownership must be real, substantial, continuing, going beyond pro forma ownership of the firm as reflected in the ownership documents. The regulations further state that the DBE must be independent and it can't rely on one business entity for its viability. What does that really mean in layman's terms? It means that you can't have you can't be a male and simply say your wife owns a construction firm, but she's not really doing any work, and get her certified as a DBE, or you can't be a white business owner and grab a black friend of yours and say, well, it's owned by an African American and therefore a DBE. No, the ownership by the socially and economically disadvantaged individual has to be legitimate. The other area of the regulation really goes to preventing a situation where somebody has almost a wholly owned subsidiary, and I know it occurs out there, as I do the first type, where there's folks that more or less recruit socially and economically disadvantaged people to form these companies. I'm not saying it's right, but it occurs. The other is where a non-DBE firm has sort of this captive DBE, and in both cases, that's a violation of the regulations and is indicative of what can be considered a front scheme. Well, an example of a fraud scheme, and one that was just recently in the news as of January, is what's called the Schuylkill Products case. Why it was in the news in January was that two of the executives that were involved were given their sentences, and we'll get to that in a second. But the Schuylkill Products case is considered the largest ever DBE fraud investigation by the FBI. The fraud scheme itself took place over 15 years on 300 projects and involved $136 million. That's another one that cuts close to home because it involved PennDOT-related projects. There, Markina Construction, a certified DBE, remember what I said earlier, which is all of these cases involve the use of certified DBEs, and just simply grabbing a certified DBE is not going to be enough to protect you. Was awarded $136 million in PennDOT projects because of its DBE status. However, Markina actually performed no work. They performed no commercially useful function. That work was instead performed by Schuylkill Products. And Markina, the investigation revealed, was established by Schuylkill Products for that very purpose, to go out and obtain these lucrative DBE projects through their status as a certified DBE. So while there was that somewhat of a pass-through here scheme, it also involved a front scheme because of Schuylkill Products' active involvement in the organization and establishment of Markina. So what happened? Well, each individual defendant, the president and vice president of Schuylkill Products, as well as the president of Markina, received federal prison sentences of between 24 and 33 months. In total, $119 million in restitution was paid. Several fines in the several hundreds of thousands of dollars were paid, as well as their legal fees, which probably equal or exceeded their fines. Now, you'll remember earlier where I said that, at least I had alluded to the fact that even if you're not operating under the Federal Department of Transportation DBE program through a state transportation agency or a regional transit authority, you still cannot ignore complying with a state, local, and municipal program. So if you're out there, you say, well, I don't really bid on jobs, I don't work on jobs that fall into this program. Well, you may be working or bidding on jobs that fall under, where I am, the city of Philadelphia has its own program for government projects. Many counties have programs similar to the Department of Transportation's program. And the reason you can't ignore it is that DBE fraud, in and of itself per se, is not a crime. The crimes that are committed in the course of committing a DBE fraud are mail fraud, wire fraud, conspiracy, money laundering, racketeering, and making false statements. The prosecutors will often refer to mail and wire fraud as their best friends. It's because anytime the mail service or wire system, interstate wire system, that can be phone or internet, is used in furtherance of a fraud, you have violated the mail and wire fraud statutes. Conspiracy to commit is something done in furtherance of committing those acts. So as you can see, if you're engaging, or you know someone's engaging in a pass-through scheme on a state, local, and municipal project that has its own program, if you use mail or wire, the mails or wires as part of that fraud, that could be submitting a payment application, submitting a bid, the list goes on and on. You could be subject to indictment on federal charges. It does not matter that you are not working under the DOT's DBE program per se, because violating the program per se is not in and of itself the violation of the law that's occurring. It's one of these various underlying statutes. Now, moving on to the other area that should be concerned, and in some ways is something I don't think construction prime contractors are really worried about, and even subcontractors to that fact, is whistleblower and whistleblower lawsuits in the form of False Claims Act actions. Excuse me. Now, under the Federal False Claims Act, and depending on what state you're in, there are also state False Claims Acts that track the Federal False Claims Act. The Federal False Claims Act only applies to federal funds that are obtained through false claims. There could be a corresponding state act that relate to state funds that are received through false claims. But in both instances, more or less, it authorizes a private individual to bring a civil action, and in the case of a Federal False Claims Act, in the name of the United States, against anyone who fraudulently obtains property from the government. As I like to say, it makes former or disgruntled employees bounty hunters, because it authorizes the private individual to receive up to 30% of whatever is recovered on behalf of the government. And as you can imagine, it's a growing area of interest for the plaintiff's bar. Trial lawyers, the folks that used to sue tobacco companies, are now looking for their next deep pocket. And it's a very lucrative area for the plaintiff's bar, because what they have to do is prepare a complaint. They file it under seal. They find a disgruntled employee or an individual that has the information. They file the complaint on behalf of the United States government, and it gets filed under seal. A copy of the complaint, and that means it's not available for public viewing. A copy of the complaint gets transferred to the Department of Justice, who reviews the complaint. And if it feels it's necessary, the Department of Justice will actually take on prosecution of that False Claims Act action. So you can imagine, from the plaintiff's lawyer's perspective, if they draft a complaint that's interesting enough to the Department of Justice, they can more or less just sit back and wait and hopefully get their portion of the 30% that their private individual collects. So what are the elements of a whistleblower lawsuit, a false claims lawsuit, also known as a qui tam lawsuit? There must be a claim. It must be false. There must be knowing conduct. It must be materially false statement, and the intent must be to have the government pay. Now, what can be a claim in the context of a construction project? A payment application, a request for a change order. It could even be a delay claim at the end of a project. But in the context of DBE fraud, it's really certifying that a certain percentage of work has been performed by a DBE firm or set of DBE firms. So if you're submitting it, if you're on a state transportation agency project, one of the documents that's going to be submitted with your payment application is some form of certification saying that these DBE firms perform work as part of this payment application, and this is the percentage of work they performed. If that's incorrect, you've now submitted a claim. Claim for partially federally funded funds, and if that claim's inaccurate, you could be headed down the path for a False Claims Act. I'm going to get to knowing conduct. Knowing conduct is not necessarily intentional conduct, and we'll talk about that and its impact on claims, on whistleblower claims. An example of a whistleblower False Claims Act lawsuit, I think this was in 2012, U.S. versus Testech. Testech was a certified DBE. Unlike the pass-through schemes that we were talking about, there was never an allegation that Testech did not perform a commercially useful function. It had its own employees, had its own equipment, and it acted as any other contractor would act on a project. Rather, the claim was that Testech was not actually owned and controlled by the socially and economically disadvantaged individual that it said it was owned and controlled by on paper. What the claim was that a non-DBE firm, a firm by the name of CISO, actually controlled Testech, and Testech was more just a puppet for CISO. And I underscore it, the claim began as a whistleblower lawsuit. A disgruntled employee of Testech brought this claim, went to a lawyer, filed a private action in federal court under seal, which was then picked up by the Department of Justice. What happened? Well, the individuals that were involved in this DBE fraud, they paid $2.8 million in fines, and perhaps most strikingly, the former employee whistleblower received over $500,000 for their role in bringing this case to the attention of the Department of Justice. And it was all because Tesco submitted claims, payment applications, certifying that, yes, I am a certified DBE that's owned and controlled by a socially and economically disadvantaged individual, when in reality they were not. A former employee got wind of it. They brought that claim. This just easily could have been a pass-through scheme where a disgruntled employee sees that you're submitting payment applications certifying a certain percentage of work being performed by DBEs when you're not doing anything to monitor compliance, and may actually know that the DBEs that you're certifying as having performed work aren't actually doing it. Now, recall me saying that lack of knowledge is no defense. Neither to a criminal indictment nor whistleblower action, neither of those requires that a prime contractor act with actual knowledge in order to be found liable for DBE fraud. There's something known as the ostrich instruction, and it's a jury instruction given if a defendant claims lack of guilty knowledge where the evidence supports an inference of deliberate avoidance. I think this really goes to the heart of why we're all participating in this webinar today, and it's the huge cost of noncompliance. For many years, the program, the DBE program, was one that was not taken very seriously. The notion of compliance wasn't taken seriously. Things such as pass-throughs and fronts occurred on a regular basis, and people have gotten complacent. Prime contractors have gotten complacent. They may suspect that a firm isn't actually owned by a socially and economically disadvantaged individual. They don't have any specific knowledge of it, but they may suspect it. They may suspect that a pass-through scheme is going on one of their projects. They may not be a knowing participant in it, and they may just turn a blind eye. They may become the ostrich and stick their head in the sand thinking they're okay. They're not. They're not. Because of the ostrich instruction and because of what it takes to prove a whistleblower action, which is less than actual knowledge. It's reckless indifference. It's deliberate avoidance. All of those can serve as knowledge under a whistleblower claim. Just to underscore this point, a quote from a case, United States versus Leahy, involving a DBE fraud case. The failure to ask questions that would certainly arise from the circumstances is evidence that could lead a jury to determine that the defendant deliberately avoided learning about the scam. So you simply can't just sit back anymore. If you suspect that there's DBE fraud going on your project, you need to probe further. I mean, you probably need to probe further, not just because of this, because your contract requires it, and you could also find yourself being on the wrong end of a breach of contract action. And I know there's some questions pending. I'm going to save those to the end. I think it's just easier to work that way. Yeah, to go back to something I had mentioned previously, the lack of knowledge being no defense in regards to a whistleblower lawsuit. Remember, one of the 5 elements of a False Claims Act action was knowledge and knowing, that you knowingly submitted a claim. That includes actual knowledge, obviously, but like I said, deliberate ignorance and reckless disregard. Proof of a specific intent to defraud the government is not required. So it's a low threshold to get tagged on a whistleblower action. And the other thing about whistleblower actions, just to go back a little bit, is that even when you win, you lose. Because if you are a private individual finds the right plaintiff's firm to bring this action, you're going to have to hire an attorney to defend it. And God forbid the Department of Justice, with the full resources available to it from the federal government, gets involved. Even if you end up defeating it, what do you ultimately gain by that? And and we'll talk about why it becomes at that point so important to keep certain records and what you can do to protect yourself. I have a list of certain red flags here. I'm going to send a copy of these slides to everybody at the conclusion of the program. You can take a look at them. We'll just skim through them quickly. I think it's important to know what investigative authorities look at when they're investigating the lack of a commercially useful function. What it all really goes to is this firm real? Are they actually doing things the way it's normally done? I want to talk about what I call the second hidden danger of not complying with DBE rules. It's a bid rejection and challenge. If you recall at the beginning of the program, I mentioned that the quotas, a strict set aside saying that this certain percentage of work must be given to a certified DBE is not permitted. That would be unconstitutional. It's also explicitly written in the regulations that these are goals and not quotas. And what's also explicitly written in the regulations is that a bid cannot be rejected for failing to meet the stated DBE goal. So if a request for proposals goes out and says we have a 10% DBE hiring goal on this project, if you submit a bid that's at 8.5 or 9.5, you can still get that project. The agency can't reject your bid because you didn't meet the goal. And I think that is a common misconception that gets many contractors in trouble. They feel that they have to show that they've met or exceeded the goal when in fact they don't. And in the course of trying to meet or exceed that goal, they get a little loose with who they're listing. They're getting aggressive with how they're going to attempt to meet that goal because, in reality, meeting these goals is not an easy task. Sometimes there's just not enough competent DBE firms out there to perform the work, and you really need to make a lot of efforts to get those contractors. But, and this is a big but, you must demonstrate good faith efforts in attempting to meet that goal. So you simply cannot, in the case of a case we'll talk about, send out a blast email to a bunch of certified DBE firms asking them to submit a bid on your bid proposal for a portion of the work that you are considering subcontracting to DBEs to meet your goal. Appendix A of the regulations actually sets forth a pretty robust list of efforts that will be viewed. It's not a bright line test. It's not an exhaustive list, but it is certainly helpful guidance to prime contractors what you can do to demonstrate good faith efforts. And what they're saying is good faith efforts are aggressive efforts in soliciting the work, breaking out portions of the contract to increase the likelihood that a DBE goal will be reached, and that you can find DBE contractors that can meet the goal and actually perform the work. Subcontracting work out that you intended to self-perform, aggressively negotiating prices with DBE firms, and I don't have it on this list, but just because a DBE submits a price that may be somewhat higher than a non-DBE firm, you can't just reject the DBE firm on that basis. That's not going to be good faith efforts. And I mentioned a case where somebody had a bid challenged and rejected. It just recently happened out in Montana. What happened there was I believe a 7.2% DBE set aside, goal, and the contractor submitted a bid, and they were just there. They were at like 6.8 or 6.9, and when the Montana DOT reviewed the bid, and asked for the evidence of the contractor's good faith efforts, what the contractor did was simply send out a blast email, like I said, to 160 DBE firms asking for bids. And the state transportation agency, as they can reject the bid. If they had just done a little bit more, had documented what efforts they undertook in meeting the goal, and had not simply just hit send on their email, they may have received that bid. And why that's important is they may have received not only the profit that they expected to make on that project, but as many of you know, it's not cheap to put a bid together, especially on a large construction project. So they were out the money that they spent putting that bid together, which can sometimes be in the hundreds of thousands of dollars. The other area is the post-compliant audits. A post-compliant audit that state transportation agencies have in their contracts. An example of a post-completion audit comes from PennDOT. In each PennDOT contract, PennDOT reserves the right to determine whether or not the actual DBE expenditures complied with the DBE goal, and if not, PennDOT is empowered with a whole host of sanctions, up to and including referring it to the Department of Transportation Investigator General, or even the Department of Justice. You can be disbarred, but you can see the risk of even getting through a project where you're not paying attention to what you should be in terms of DBE regulations can get you in trouble. Here's a letter that I found on the Department of Transportation's website, and it's an example of a letter that the DOT Inspector General would send out to a prime contractor. And think about it. They're talking in this letter that they believe that they subcontracted work and did not have the DBEs perform a commercially useful function, and they're going to seek about $1.8 million back from the prime contractor. If that happened, and the Inspector General was successful in recovering $1.8 million from the firm, would your firm be able to survive that? Just writing a check over for $1.8 million? That's the question you need to ask. It's easy for the Skanskas of the world and the Perinis of the world to do that, but I think for many prime contractors that aren't in that level, they'd be hard pressed to do it. So, what should you do? Well, what are you doing now, and when was the last time you tested your firm for compliance, and how well it complies with DBE audits? There are the two questions you need to ask. What we're recommending firms to do is to actually have a DBE compliance audit performed. That's important because it's going to ferret out those areas of compliance where your firm may be weak in. I think it's also important to have that performed, that in the case of a broad investigation, having specific policies and procedures in place, having determined that you took good faith efforts in order to comply and show compliance, and you brought in an outside firm to do it, it's going to hold weight with investigators. It's going to make it look like you're less of a crook, for lack of a better term. So the step one is performing that audit. What do you have now? Do you have that DBE compliance officer? Do your contracts have the DBE specific language requiring your subcontractors to comply with the regulations as well as you? What are you doing to record your good faith efforts? And that's key. What do you, if you want to survive a bid challenge, not only by the agency, but by another bidder, are you documenting what you did? And that's not necessarily a difficult or time-consuming thing to do, especially now with all the technology we have. What are you doing to aggressively solicit work from DBE subs so that you can put in the truthful amount and not have to worry about it being challenged? And what do you do when you have an inkling that there may be a potentially commercially useful function red flag going on, where you think somebody's not really actually performing the work. You see somebody else's stickers slapped onto the side of a truck, and that somebody may not be performing the work they say they are performing. What do you do about that when you get it? Step 2 would be to institute those specific DBE policies and procedures in the form of a manual, followed by periodic testing to make sure that your procurement departments and your other folks that are dealing with these regulations on a day-to-day basis are actually following those policies and procedures. And again, barring something from the financial world where compliance has been an issue for a number of years, most of the large financial firms have compliance manuals. They do periodic testing to make sure that their employees are complying with it. And in the Department of Justice's sentencing guidelines and investigative guidelines in the financial world, they say evidence of having a program in place to assure compliance with the various financial regulations is a mitigating circumstance. Now, there's not something like that in the construction industry, but there's no reason why that argument can't be made to federal prosecutors or Department of Transportation investigators if an investigation is initiated and you want to snuff it out early on and try to resolve it with as little impact to your company as possible. We've reached the end of the program. I'm happy to take any questions. There was one question I think we have here, which is, how did they determine it was not an actual DBE firm? Well, how would you actually determine it's not a DBE firm? An investigation is launched. One of the letters that we saw typically happens is a letter that's sent under the DBE rules. The state agencies that certify DBE firms retain the authority to investigate, to make sure that the DBE firm is actually still within the DBE certification guidelines. From a Department of Justice perspective, there can be grand jury subpoenas. There are a whole host of legal procedural ways that an investigation can obtain the information necessary in order to determine that a firm wasn't actually a DBE firm. I think in the case, if you're referring to specifically that Tesco case, it was a disgruntled employee. They had the information. They knew that, I think he was an Indian American gentleman. That disgruntled employee knew the Indian American gentleman was not actually the owner of that company. And he had proof of it. So he went to an attorney and said, look, here's the evidence I have that it's actually owned and controlled by this other firm who's not a DBE firm, and I want to file a whistleblower complaint. So there in that information, the evidence of non-DBE status came from a disgruntled employee. That's why it makes it such a risk, because anybody that you lay off now has the potential to go out and hire a lawyer and say, hey, I work for this construction firm. I do a lot of work for the Department of Transportation and for PennDOT or for DelDOT or the MTA, and they say it's owned by this gentleman who's Indian American, but he's really not. It's really not. It's owned by this guy who's an Irish American. So that's what you have. So I don't see any more questions. I hope everybody enjoyed this webinar. Everybody has my contact, or should have my contact information, because I'm going to email a PDF copy of these slides to everybody. This is also being recorded, so I'll email a recording to you all. And then if anybody has any follow-up questions, they can reach me directly. Thanks a lot, and have a good weekend.